Welcome to the Notes to My Legal Self, AI Insights, where law and AI collide. Get ready to level up your legal game with us. We've got career advice, cutting-edge developments, mind-blowing legal tech, and more. Know someone making waves in the legal AI world? Nominate them, or even nominate yourself. We love courageous souls. And don't forget, we want to hear from you too. Ask questions, drop comments. Let's build a community of legal superheroes. But here's the deal. We're all about to have a blast. AI may be serious, but we're here to make it fun. So buckle up, get ready to power up, and let's embark on this exciting journey together. Now, let's introduce your fearless host, Olga Mack. Get ready to dive into the awesomeness of Notes to My Legal Self, AI Insights. Let's go.
All right. Well, hello, everyone. And yes, let's go. There's going to be a very short introduction because this is definitely a repeat guest. And the reason we're late is because I couldn't get enough of him in the hair and makeup room before we went live. So without further ado, Damien, welcome back. It's good to see you. I'm so excited. Please
Good to see you. I've got all my makeup on and my hair is doing fine.
I thought you would relate to that. I am so glad. Please reintroduce yourself.
Damien Riehl, my day job is with VLEX, where we have 1 billion legal documents that I run data science and run large language models across those. And in my nights and weekends, I help lead the nonprofit that is SALI. That is the legal data standard that's being used by Thomson Reuters, by LexisNexis, by VLEX, obviously. I manage net documents and largest law firms in the world and the largest corporations in the world to make data more interoperable. So I do lots of things, and those are just two of them.
I love it. I love people who do lots of things. Those are my favorite people, and I can totally relate to that. Last time we had a very long conversation, and we geeked out. What would have, should have been, I guess, copyright conversation became a much larger conversation, and we essentially went into business models of law. And then I asked, well, how are we going to be making money? How are we going to have a standard of living that is as good or better than the one you have before? And you said, Olga, I have answers for you. Good. I'd like to have answers, Damien. I would love to have answers to standards of living conversation. So, easy question. How will LLMs change the way we approach law and make money in it? Let's do it.
Sure. So, and of course, Yogi Berra has said that the future is hard to predict. I'm sorry, that it's hard to make predictions, especially about the future. That was Yogi Berra saying that. So we're going to be predicting here, and of course, it's hard to make predictions. So I would say that nothing that we're going to say here is going to be the dead-on truth of what the future will be. But I think we're all thinking about what are potential paths of where we're going to be.
Thank God. I thought Damien is going to say this is not going to be legal, financial, or investment advice.
That's right. That's right. No, I will not be saying that.
That's true too. But I was like, oh God, we're in a conversation where Damien gives disclosures. Okay, cool. All right.
Yeah.
Let's do that.
So this is a potential future. So yeah, so it's thinking about like if we are in a world where we are actually today, where you could do a 10-hour legal research task, or you could ask my tool and you could do it in 2 minutes. So how are you going to bill for those 10 hours? And will clients who now themselves can do that research for 2 minutes, will they put up with the 10 hours? That's the real question. And if the answer to that is yes, the clients will put up with you spending 10 hours kind of thing, we're not going to change at all. So we don't need to even worry about changing business models. Okay, so that's world number one. But if world number two is the clients that are now saying, hey, why did you bill me for 10 hours for that thing that I know that VLEX can do for 2 minutes? Then we have to think about, well, gosh, if I now am not able to build those 10 hours, how do I shift my thinking? And of course, we've talked about the death of the billable hour for a bunch of years, but I think that's the wrong paradigm. The billable hour is never going to die, but the current, billable revenue is about 85% of the law firm's revenue, whereas flat fee revenue is between 10 and 15% of it. I think what we're going to see is that, flat fee is going to increase, and billable is going to decrease. And I think that, billable rates dying is probably never going to happen because there's always going to be some uncertainty with some bet the company litigation or some weirdness. But I just think that the percentage of hourly billing, the percentage of flat fee billing is going to increase as the clients really make that happen.
Okay, we'll definitely get to the billable hour because everyone seems to want to talk about it. It's a sexy conversation. It really gets people excited. So we'll get to that. But let's talk about World 1 and World 2, that you talked about. What are the chances, now we're at the door, going left, going right? Is there a third door? Sounds like there are two doors, maybe three doors. What are the chances? What's behind door one? What's behind door two? What are the chances people will go either direction? Thoughts?
Yeah, so think about let's stay in door number one, where the billable hour remains king, and or queen, as the case might be, and the clients don't actually push us toward flat fees. If we stay there, and now my 10-hour task only takes 2 minutes, you can imagine maybe the option I as a lawyer take is maybe now I get a chance to answer question number two, and question number five, and question number 10, and question number 50. So in that 10-hour span, I would have actually answered maybe 50 legal questions, where before I would have just answered one legal question. So maybe I spend the same amount of time on that task of legal research, but I just ask way more questions and then give my client a much more robust, much better answer than I would have only with the one. So we could stay in this world number one billable hour and still make the same amount of money, but just do a better, faster, stronger job billing the same amount of time.
All right, door number two. What's behind door number two? And is there a door number three? Because a good lawyer presented with two choices will come up with infinite number of other choices. And I know, Damien, you're a good lawyer, so I am flagging the door number three to you.
That's right. So let's go to door number two, and I do have a door number three. So door number two is
Wow, I'm so surprised you have a door number three.
yeah, it's true. Well, litigators, I tend to be predictable. So door number two is I, as a client, that is I as a corporation in-house, know that it only takes 2 minutes to do this thing. So I'm going to say, no, don't do 50 things. Just do the one thing that I want you to do. Or by the way, I can do it myself. So if you don't do a flat fee, then I'll do it myself and I'll take that away from you. So if we go into that door number two and we go to the flat fee model, then really the question is, how much is the law firm going to do and how much are we as in-house clients going to do? That is a negotiation. And so if I'm a law firm as part of that negotiation, I have to say, what am I doing that is atop what the machine can do right now? And how can I price that flat fee in a way that is profitable for my law firm? And so when we think about profit, we think, any business person will say that there's revenue minus the cost that it takes to do the thing. And the difference between revenue minus cost equals profit. So as you press down the cost, that is, as you do the 10-hour task in 2 minutes, you can actually increase your profit. So we as lawyers can actually make way more money with a flat fee than we would have otherwise with the billable hour, because with the billable hour, maybe our cost was really high, but our profit margins were much smaller. So if we press down those costs with the flat fee, maybe we make more money. So I think that maybe is a good future.
There's a maybe, so there is an uncertainty. So what's the full disclosure on uncertainty?
Well, the real question is then how low will the client want to push that flat fee? And that's really a negotiation between law firm and client, saying, because the client is thinking, well, I know if you're charging me a flat fee, I know that you're baking in your margin. So I, as a client, am thinking, how big is your margin and how much can I squeeze your margin to be able to get the best deal for me on the flat fee side? Because I, as a client, don't want to get screwed by my law firm. I don't want you to make a huge profit margin on me. I just want you to make enough profit to be good for both sides. So that's the negotiation side.
Oh, how interesting is that to make a small margin? You're not selling it very well. Door number three, what's behind door number three?
Well, door number three is a hybrid between door number one and door number two. Maybe some of the things that we do are always going to be hourly. When people that know me know that I worked for a large law firm, worked for Thomson Reuters, but then I worked in cybersecurity. And cybersecurity, there are so many unknowns in cybersecurity. Like I would be amongst the team that if you got hacked, I would bring my team in and figure out where the bad guys are and help get the bad guys out. So if somebody engages me in that process, I have no idea who the bad guys are. I have no idea how deep they are into the system. I have no idea about how long it's going to take to get those people out. So of course, I'm not going to flat fee that, right? Because it might take me hundreds of hours to get those people out, and I don't want to lose my shirt on the flat fee. So in cybersecurity, of course, I'm going to do an hourly bill. So I think there are analogs in the legal sphere. There are some things that we know a lot about in litigation, and there are some things that we know a lot about in transactional space, but there are a lot of things that are lots of unknowns, and that we will always have to go back to the hourly.
Yeah, well, a lot of people, when they want my thoughts, they usually ask me about value billing. They usually get in touch with me and ask me how much would that be worth. And most businesses, when they build products, are trying to ask a question, not what my costs are. Well, I mean, those are basic costs, yeah, but what value am I bringing to you, and how do I get as much of consumer surplus out of this than what I can get away with. That's a sort of this the art and science of pricing things. So when I talk to lawyers about various services, they are really interested to get a chunk of the value they create. And it becomes a little bit difficult because you don't always know that, the tables shift a little bit, and now you as a lawyer don't know very much about your client's business and industry nearly as much. So, is there another door, or is it one of the doors already? I'm not sure why I'm constraining to doors. I'm known to go through chimneys and windows and dig tunnels, but let's stick with doors. Value billing. Any thoughts on that?
Yes, value billing is definitely something that we should, as lawyers, be thinking about much more than we currently do. And to do the value billing, some lawyers charge $1,000 an hour or more than that, say $1,500 or $2,000 an hour. And the reason for that is because their hour is much more valuable than the first year associate that works in the law firm. So really, you can imagine that $2,000 an hour person doing a flat fee for the value that they're providing as $2,000, and the
Well, to be
clients.
clear, what I want is percentage of, say, the value created to shareholders. Like I don't want a higher rate. I want 1% of whatever surplus that I create.
That's right, and so that's so that value billing, yes, definitely do that. So to the extent that I hire a contractor not for how long it takes for that contractor to do it, and not for how much it costs that contractor to be able to hire the subcontractors. I want my building done, right? So in the client scenario that you gave, I want Olga Mack's really amazing legal advice, and what is the value for that? Well, maybe it's a percentage of equity or whatever it is. So I think that really we in almost no other sphere do we ever think about what the seller, how much time it takes and how much cost it is. We only think about what is the outcome and how valuable is that outcome to me. Maybe that's valuable enough to give you equity. Maybe it's value enough to give you a flat fee. But either way, it's not dealing with how much time you're spending on the thing. Really, either way, it's just thinking about how much
Yeah, the
value I'm
only
getting.
wrinkle here is the bar regulation because now you have interest in your client and you have an argument that the fees were too high, and every bar in the nation has reasonable fee provision. And we can argue whether doing what the rest of the world does is reasonable. But I think one of the reasons we have an hourly model is because it's a very quick way of saying this is reasonable because I charge by an hour. Let's talk about, maybe I want to talk about billable hour because I told you we're going to get to that conversation. So what will LLMs and AI and automation and everything else that is coming on a tail of this success story do to billable hours? Not, maybe not ultimate death, but more of a slow fall. People talk about Venice, that it's not going to be a glorious death of tsunami. It's going to be just rotten over time for the next couple of 100 years. Is that what we're talking about, the slow unglorious rotten?
Yeah, I think so. I'll address both of the things on the reasonable, what is a reasonable fee. I would say that one thing that the bar considers is what is reasonable fee in Manhattan is not the same as the reasonable fee in Podunk, Nowheresville, right? So you can imagine if enough law firms are taking equity in their clients, maybe that is a reasonable fee in Manhattan amongst their peers. So really, I think reasonable is whatever we as an
I mean, I
industry
think there's
decided
a.
it.
So you think it's only geographically constrained? I think it's because we are a self-regulated industry. The reasonableness is there because we do have a superior knowledge, and we add as expensive as we may be. Some of us add quite a lot of value, and I do think that that's sure geography will dictate the prices. But if we talk about, I think the the exchange with self-regulation is exactly that, is that we actually undercharge for some things and as a result underserve many.
Yep, I think I agree. And mostly my point about the geography is that if the New York Bar Association were to say, is that a reasonable fee that Damien charged for that? They would compare it with other New York lawyers. So if enough lawyers in New York do the equity take, then say, that would be reasonable under New York. And so really, I'm just thinking through the enforcement mechanism. If someone were to do a complaint against Damien for charging an unreasonable fee, they would do that in New York. And so I'd be compared with my New York peers. That's mostly what I was thinking about for the reasonable fee side.
Yeah,
Um,
and hourly gives you that comparison. Like we all within a couple of $100 charge the same fee, and unreasonable can be benchmarked. Like it takes Damien 100, it takes Olga 130. She's 30% up or down. That seems like a good spread. Olga is reasonable.
Yeah. And you could also say, yeah, here are the 12 other people that took equity in their companies. That's reasonable.
Yeah, but equity has a component of risk.
Mhm.
So, and that could swing either way. And nobody will complain if Olga loses money. But what if Olga makes so much money that Olga never have to work again because she took risk? Is that unreasonable?
Yeah, that's the right question to ask. And of course, I'm not an ethics lawyer, nor do I done the research on this. But I would guess that yes, because there's risk. At least this would be my argument if I were brought up as being taking an unreasonable fee for now having FU money for being able to retire. I
It's
would
not a
argue
few money, it's very well earned.
that's right.
Damien, it starts with our attitude. And then I
That's
want
right.
to correct this very intentionally because if we want to have different models, it's
That's
not
right.
an FU money. It's all earned through risk and intelligence.
And the risk is what I really wanted to say is, yeah, that the risk. So, like, I'm taking the downside that if this company goes away, I get paid $0, right? So, with the downside, I take that, and with the upside, I take that too. So, really, that would be my argument to the regulators, saying that no, this is a reasonable fee because I can take both the downside and upside. That's thing number one, and thing number two, look at these dozens of others that are doing the same thing like me. So, if it's not reasonable for me, maybe it's not reasonable for them. But under the reasonable person standard of any legal analysis, it's how many other peers are doing that. And if a lot of my peers are doing that, then maybe it's fine.
Yeah, I don't want to be a test case for that. That sounds all reasonable. I just would like somebody else to go through pleasure and joy of dealing with the bar of any state.
Yeah, that's true. Yeah, and nobody wants to be brought up on ethics charges. But what are the odds of anybody bringing up, like, who's going to bring up the charge? It's going to be your client, maybe. And what client is going to be say that that they now I've done a windfall? No client is
Look,
probably going to do
what
that.
I know for sure, here's my observations on this topic is that unauthorized practice of law is very much something bar is looking into, and it's a real stopper for developing technology, and it is enforced and criminalized in some of the states. And so that's one benchmark. And the second benchmark is, look, I mean, you look at the California bar, they're increasing fees quite intentionally, quite a lot. And most recently, what are they going to do with it? It's called enforcement. And it's going to be enforcement in this area of unauthorized practice of law for sure, because we have a rise of technology, and then of course there's going to be lawyers associated with it. And I do think that this is where you see entrepreneurial lawyers doing things from litigation finance to serving consumers. I think there will be plenty of test cases, and however slim chances are, I would rather have somebody else bear the cost of that.
Yeah, nobody. Yeah, nobody wants to be a test case for sure. And so, two thoughts on the UPL side. One that I think you're touching on is is it a lawyer-owned business or is it a non-lawyer-owned business? That's thing number one. And then two is large language models and how it affects UPL. So let's talk about thing number one. We already have Arizona and Utah that have their UPL sandboxes where you could be able to be a non-lawyer owned entity and be able to run an Arizona law firm without a lawyer owned. Let's do a thought experiment. What if that Arizona lawyer owned company, I'm sorry, non-lawyer owned company decides to go across the border and start doing a little work in New Mexico, and then maybe goes across the border and does a little work in Texas. And then what if Texas were to bring a UPL lawsuit against that Arizona owned company? There is a North Carolina case that is against the dentists in North Carolina, where the FTC had something to say about that, where they said, hey, you can't be a guild in the dentist North Carolina to be able to prohibit interstate commerce, because the interstate commerce needs to flow. So if it's permitted in North Carolina or permitted somewhere else, you need to be able to import this stuff into North Carolina. So that's the North Carolina case. You could
Yeah,
imagine
that's
in
why
Arizona.
I'm pretty familiar with. Okay, that case is rooted in antitrust. That was
That's right.
the main concern in that case. Yeah.
That's right. So maybe the same with law. right? Maybe that, if Texas were to sue that Arizona company, maybe they could bring an antitrust argument saying that you in Texas are being protectionist against another company that's legitimately able to practice in Arizona. But because they're coming into Texas, you're trying to do an antitrust guild to be able to keep your competitors out. We as the FTC want to be able to keep consumer prices low. Therefore, the Guild of Texas can't really stand the Arizona exclusion.
Look, would like to see that. Aside from the fact that there's a cost associated in litigating it and dealing with all the folks involved, and it's not fun and expensive. It's a very expensive way to have fun, maybe. Aside from that, it takes a long time, and in the meantime, I could be building stuff and actually have real impact. The opportunity cost, as much as the out of pocket cost is high, the opportunity cost is even higher. So that's why I'm very familiar with FTC argument. I actually kind of helped to develop a little bit when I was working there. It's for dentists and anesthesiologists as well in various jurisdictions. So very, very familiar with this. It does map a little bit to what's going on in law. I would be very surprised that FTC will take state bars on this. I just think it's very different. It's a very different argument when you say, hey, this is health implications on health, and and law is just like a little bit different. And I do think that the self-regulatory is what stuff we have in law is qualitatively different from the public health type of stuff.
Yeah,
um
I think that might be right. And thinking too about, the FTC is not staffed with dentists, but the FTC is staffed with lawyers. So they might be a little bit of laws different because I'm a lawyer, that there may be a bit of that.
FTC is most definitely staffed with lawyers, not necessarily at the commissioner level, but the tenured 10 plus year who've been doing this. There are other professionals, technologists, and stuff like that increasingly there as well, including most recent expansion. But yeah, it is a very much a legal organization, and so yeah, I think it's for that reason too. That was I was not thinking that, but you're right, absolutely.
Yeah, so
Um,
they're not going to want to go against their own that way. And so that was thing number one on UPL is the ownership. Thing number two on UPL is large language models and whether that is the unauthorized practice of law or not. You may or may not know that the Minnesota State Bar Association has appointed me chair for a commission, a working group to determine whether or not AI is or is not the unauthorized practice of law. And as part of that, we're also saying, to what extent can large language models help with the access to justice problem? So if we think about that thing number two, UPL and large language models, think about who you can go to Google right now and say, what are the elements of breach of contract in New York? And it will give you a delineated number of the elements of breach of contract. That is just legal information. That's absolutely fine. You could also go to Google, say Gemini, and be able to say, now draft me a motion or a complaint against with all of these facts, with all the elements of the complaint for breach of contract in New York. Google will also do that, as will OpenAI, as will Microsoft, as will Meta's Llama model, as will Mixtral, as will all the others. So really the question is Google practicing law by taking your specific facts and applying those to the law? And is
well,
Google
I
doing
mean,
that?
to
Is
be
Microsoft?
clear, I think this is where the fees will go.
That's right. It could well be. And so really the question is, if you are a legal tech company that's being alleged to do the unauthorized practice of law by doing this work, you can imagine the legal tech company doing a PR campaign and being able to say, wait, you as a bar association are punching down on me, but you're not going after Google. You're not going after Microsoft. You're not going after Facebook. And why would that be? Well, maybe that's because you maybe wouldn't win those arguments, but you're punching down this way. So if
Yeah,
they,
no, I mean, independent of what I think, right? Independent of what I think, when you just Google and it gives you all the sort of uh, parts of complaint to satisfy, to file it, and information, like that's easy. You're not practicing law. You may, and everybody sort of accepts that this is not accurate. This is sort of not to be relied on. At the point you give somebody a complaint, a legal document, you can tell me that negotiating contracts may or may not be a practice of law because, frankly, a lot of folks who negotiate are not lawyers, and they can say, well, they're under supervision of lawyers, so therefore practicing law under Olga's license, and God help her. But very few things are more legal in the eyes of the bar than a complaint and then filing it. And so this is very, I now created complaints using different LLMs, public and private. All of them are pretty good. And frankly, where if I were to, you know, if I will come out of my retirement and decide to actually fight for justice, I could do that. That's an alternative career that I could do. I would definitely incorporate some sort of LLM as my associate. For sure. I mean, I will, of course, revise and check citations and do all that, but I can see how, and there are an increasing number of cases where folks in small claims courts or not so small claim courts show up and judge says, oh, this is a pretty good complaint. Wait, this is exactly the same complaint I saw the guy right before you. Are you guys related? Oh, you never met. How did you guys use the same complaint? Oh, you had used Chat GPT. Oh, wow, it wrote that. And I think it would be very interesting to see, what we historically, traditionally think as a real practice of law, which is showing up and filing a complaint. Like, what I would be curious to see what would California bar think about that.
Yeah, that's the right question to ask, and it really the when we think about if that person that is either in small claims court or otherwise filing in a district court, really whether an attorney-client relationship is established is really in the eyes of the client. That is, if I want to be able to, sue you for bad malpractice, because I called your office and asked you to be my lawyer, the question that the bar will say is, did I as a client think that you're my lawyer, or did you as a lawyer give me a letter saying, I'm sorry, I will not be your lawyer? So, and if that happens, then objectively, I as a client could never have thought that you were my lawyer by just making a phone call to you initially. So that's with attorney-client privilege. But then
Basically, something along the lines of disclaimer. Hey, you user, just so this is maybe a legal document, but this is just for educational and entertainment purposes. To be clear, I may look like a lawyer, I may smell like a lawyer, you may even feel like I'm a lawyer, but I'm not your lawyer.
that's
That should address bar's concerns.
well, that's what happens today. So if you were to go to Gemini and say, Draft me a complaint," it will say at the beginning, "I'm not a lawyer. This is not legal advice. Here's your complaint." And then at the end of it saying, "I'm not a lawyer. This is not legal advice." So if you bookend that complaint with saying, "I'm not a lawyer. I'm not a lawyer," what reasonable client or prospective client would think that Google is acting as their lawyer? They would say, "No, this is just me Googling things, just like I've been Googling things for the last 25 years. Google is not my lawyer. This is legal information,
Look,
not legal
I
advice."
believe you. I mean, you convince me. I mean, I will do any. Honestly, I think I'm actually even less concerned about hallucination because the reality is we underserve 95% of the people today. And if we now gonna serve 80% well by doing them, and 20 of them, 20% will get hallucinated complaint, I think that's a fine cost. But the reality here is that traditionally we see filing or generating of complaint as a practice of law. And you can bookend all you want, and I can still imagine a bar say something along the lines. You are dealing with somebody who has eighth grade of an education. They can barely read and they misread and they can't help their life. You should know better when you give legal advice, which is generating a complaint for whatever informational or entertainment purposes only.
Yeah, but really, Google's not going to be filing that with the court, right? Google will be giving you the complaint, and then I, as a
So
litigant,
so the so is it generating versus filing? I mean,
well, I mean, that's the right question. And so that's scenario one, is that Google is generating but not filing. Scenario two is that legal tech company is also filing the thing. And some bar associates will say, well, that's a bridge too far. Maybe you've gone too far by filing, but maybe I'm not going to sue Google, or I'm not going to sue Microsoft, the biggest market cap company in the world, over this. And by the way, we haven't yet talked about the Upsolve case in New York, where they have successfully argued at the district court level in federal court that the unauthorized practice of law statute in New York is unconstitutional as violative of free speech, saying that legal advice, is speech. And by the UPL statute prohibiting speech, that is a violation of the First Amendment. And that's successfully, that is, the court has agreed with Upsolve and is now being appealed to the Second Circuit. So if you're
yeah,
going to
I've heard that. I would like to see that. I think there is a equally viable argument when you get self-regulation monopoly, you give up some freedoms of speech. I mean, you can definitely see that argument flying. And I think it does force us to rethink this self-regulated monopoly and what kind of unnatural questions and conundrums we find ourselves using logic. I mean, that's basically what it is. And as a result, people with great intentions end up underserving some really high percentage of the population. And it's not just that we're underserving indigent, we are underserving most people, period.
And that's right. And this actually is a good way that we can actually spin back to the business of law. And so, like, and since we've kind of been veering into the unauthorized practice of law, I bet many lawyers are thinking, "Gosh, you're just telling me how I'm going to make less money, not how I'm going to make more money." So let's now talk about maybe the 80% to 92%, depending on how you do the numbers, of the market that we are not serving right now. Economists would call that a latent market. That is an unexploited market that we could then go down market. That if we can take a 10-hour task and shrink it down to 2 minutes, maybe I can serve 100 clients that are low income clients that actually I could do better because now my cost is less. And so I can in volume serve many more of them and make more money on the lower end of the market. That's on the low end. And then on the high end of the market, you have my friend Darth Vaughn from Ford, who said, "Hey, lawyers, do you realize how regulated I am and how much that regulation is going up?" He says, I've got so much work that I'm not giving you right now. So he said, number one, you're going to use a large language model, because if you don't use a large language model, I'm not going to work with you. Number two, once you use a large language model, your costs are going to shrink. And therefore, I'm going to keep you fed. I'm going to give you all this work that I'm not giving you now because you're too expensive, but now because you're less expensive, I'm going to give you more of that work. So this is a way that we can either go down market on the access to justice side to be able to make more money with this latent market that is unserved, and we can go up market to the Fords of the world that say that now that my
Yeah,
cost is
I
cheaper.
mean, like that's what that's when we talk about social justice, there is sort of this connotation that we are serving indigent, but that's not true. We are underserving like more than that. Like even people who are currently served, as you gave example, are underserved. We are talking about a high percentage, like everyone who is underserved. So the market is big,
That's right. And
you
and I
know.
and even when I was at Robbins Kaplan, we associates would joke amongst ourselves. We would play the "Can I hire myself?" Question. Like, can I afford with my associate salary with this, which was we were paid very well, but even we couldn't afford our own salaries, and so our own billable rates. So if we can't afford us, what good does the middle class person have to be able to do that? So really, we are serving small businesses, homeowners, like these people that are not poor. They've got money, but they just don't have enough money to pay the $500 an hour, $800 an hour, whatever your market rates are. So I think that we can, however far down market you want to go, you don't have to go all the way down to the indigent. You can go down market a bit and make
I
more
mean, you
money.
should go all the way up and down. And the end of the day, all of these people need to be served and maybe come up with alternative ways to finance, all the way at the bottom, because we can benefit from everyone being informed and understanding their rights. That's called, functional democracy. I'm definitely supportive of that idea, but I'm also pointing out that we are underserving, and that's a massive, as you said, latent market. So, okay, so I'm an entrepreneurial lawyer who may or may not want to deal with UPL problems, may or may not want to deal with unreasonable fees problems. I really think that every minute I spend with the bar discussing this is a waste of my life. I really do, because it's I can find a better thing to do for recreation. Like anytime, anything would be better. Sleeping would be amazingly better. So I don't want to deal with any of that. I do want to have a good living, and I want to change the world by helping people understand justice. What do I do?
Well, you could maybe let those people have access to justice, and so you can imagine. So one way, imagine Jane. Jane makes $18,000 a year, which is $1,000 more than the 17,000 threshold for legal aid. So she makes $1,000 too much for legal aid, but she's at 18,000. She's not going to hire a lawyer. So option one, as a Jane, is that I can not hire a lawyer and say I'm discriminated against at work. I can't do anything about it. That's option one. Option two is I use Google as my lawyer, and that's what people have been doing for the last 20 years. My complaint's going to suck. My answer to the motion to dismiss is going to suck. And the court's going to pat me on the head and say, nice try, but there are things called procedural rules. You didn't follow them, so you go away, and make them go away. That's the old world. But today, Jane doesn't have to stick with Google. Jane can use a large language model, and her complaint's going to be pretty good. And her answer to the motion to dismiss is actually going to be pretty good. And the court's going to look at her and say, well, wait, this is a legitimate claim. Maybe I can't pat her on the back and pat her on the head and make her go away. Maybe this case stays in the system. So if there are more Janes of the world filing these cases and they're staying in the system for longer, you might say, wow, that backlog that the court we have today, we've seen nothing yet. It's going to be a huge backlog. So maybe number one, courts should maybe use large language models to work through that backlog. But thing number two, more interesting, is that defense lawyer gets more work. that is the employer's lawyer gets to more work. So when I was a plaintiff's lawyer and IP and doing defense, the defense lawyers would say, "Oh, those plaintiffs lawyers on the patent cases, blah blah blah." I kept you employed, man. I mean, that's the same thing, right? The
Public
people.
service for you.
That's right. But the Janes of the world are going to keep the defense lawyers employed. So why are we keeping Janes from accessing justice? Why not let Janes file so that I can defend the employer in that lawsuit?
So I've talked now to number of judges now, and they all share the story of same brief and how impressed they are. To your point, the quality of stuff, Jane. Well, let's call her, I don't know, something else. I mean, why is she a Jane? Can she be something else?
Plain Jane? I don't know. Yeah.
Plain. There's no such a thing as plain. By the way, did you know in my class of 24 in an elementary school in Ukraine, I was one of like 15 Olgas. So I'm like a definition of Ukrainian plain Jane. That's why I really take,
Okay.
offense with that.
We can call Olga. Olga is the one who is I'm representing.
But okay, cool. So if I am graduating from law school today, and we need to wind down because we've had this conversation for a little while, and it's time for us to say goodbye soon. If we are graduating from law school today, or I'm in the middle of my career, or I'm at the end of my career, and I'm going to ask you the same question because in the end, it's a standard of living question. Like what I'm working on is part of it, and whether I am willing to reskill is another part of it. But really, a big part of it: can my family and I can have a standard of living as good or better? And if so, what is my strategy?
Sure. I would say that the question is not, will I make more money? It's the question is, how will I make more money? Will I make more money by jumping over to the flat fee side and pushing down my costs and then increasing my profit? That's one way to make more money. Am I going to make more money by still doing the billable hour, but then just giving my clients a much better service and doing those 50 legal questions rather than just the one legal question? Then I get more clients. Maybe that way I make more money. A third way I can make more money is going down market to be able to serve the Janes of the world and to be able to serve the middle income people of the world, the associate law firm people that can't afford their own rates, but that can afford you. So going down market that way, or maybe you're going to make more money by going up market, going to the Fords of the world, by being able to shrink your costs so that the Ford will actually keep you fed and actually hire you for more stuff than you have in the past. So it's not the question of if I will make more money or not. It's a question of which of these doors am I going to go through to make more money? And now I think you've said 2 doors. Is there a third? I think I've given you 5 doors now that you can walk down.
I think we have an infinite number of doors, Damien. That makes us pretty good lawyers. How
That's
about
right.
that?
That's
How
right.
about that for a mutual compliment? Okay, 2 questions we're gonna leave with. Ethics. How do you steer away from ethics issue? And my last question to you will be, what is your prediction for the, bar regulations, that grant of monopoly that we enjoy slash love to hate slash maybe enjoy, maybe that will be a slow, unglamorous death?
So let's talk about ethics. We've talked. I've spent the whole weekend working on my working group, my Minnesota working group on UPL. So I've been thinking a lot about ethics. Some of the ethics are saying that you need to ensure that your client confidentiality is sacrosanct, and of course you do. You need to ensure that that you're not doing anything that's untoward. Of course you do. But there's also an ethical rule that you need to charge a reasonable fee. And the question is, if I charge my client 10 hours for something that everybody else is charging 2 minutes for because they're using a legal large language model like mine, tool like mine to do 2 minutes rather than 10 hours, is 10 hours a reasonable fee or not? Or am I charging them an unreasonable fee? So I think that we should be thinking both about, yes, confidentiality, and yes, all the don't be untoward, don't be stupid, but also think about how much of a reasonable fee am I charging, and can I be, how soon is it before I'm brought up on charges that I'm outbilling my people? And this has precedent. This isn't unheard of, because it used to be that we used to do paper discovery, but now if you do that today, there are cases out there saying, no, you can't do that because that is unreasonable. to do that. You need to check your email, even though in the past they said I'm never going to email. But if you don't check your email, then you're doing unreasonable. So I think that each one of these, that the ethics goes both ways. Confidentiality, yes. Reasonable fee, yes. We should think about those. And then the second, with your second question about the bar exam and the bar regulators, I guess the real question is how many of them will want to expend the money to be able to litigate these cases, especially if their membership is relatively dwindling, right? There aren't as many members of the bar as today as there were yesterday. That means the revenue for the bar associations are coming down. So to what extent are they going to want to fight Microsoft? Are they going to want to fight Google? Are they going to fight, Meta, Facebook? Or are they going to want to punch down to somebody else, or even punch sideways, like LegalZoom? They have an Arizona company. If LegalZoom were to do what I described earlier and go over to Texas, is Texas going to want to spend money against LegalZoom, public company, and their market cap, and what's their bankroll that they're banking up for this kind of litigation fight that they're pretty sure is going to come at some point? Is the Texas bar or any other individual bar with their dwindling numbers, are they really going to be filing those lawsuits? Maybe, but maybe not. So really the question is, if I, as an individual lawyer, want to make more money going forward, maybe I walk through those 5 doors rather than relying on this X state bar association to be able to fight LegalZoom or to fight Microsoft or to fight Facebook. Maybe I should just accept that the Janes of the world maybe get representation, and maybe I can represent the Janes employer and actually get paid more than trying to wail against the unauthorized practice of law and those kinds of non-lawyer owned entity arguments.
Or perhaps I create technology to help Olgas of the world.
That's right. And that is also God's work, right? I mean, that's the Olgas of the world or the Janes of the world, they need representation. And it's we as lawyers, we've made an oath as we became lawyers. We said that we need to support the equal justice under the law. And the fact that 80 to 92% of the legal needs are unmet because we lawyers are too expensive, because we don't want to roll out of bed for the Janes or the Olgas of the world, we should be disgraced by that. I'm disgraced by that. So if you could build tools to be able to help the Olgas of the world, to help the Janes of the world, lawyers don't fight against it. Let that happen and then represent the Olgas or Janes employer and make more money in the process.
Oh, I love it. I love it that we end on that high note. Thank you so much. I really appreciate this conversation. Thank you so much for joining. Thank you, everyone who asked questions. There's a robust chat going on. There's a lot of opinions on this. It's a great conversation to have, and maybe one day we will serve everybody. Thanks, everyone, for joining. Bye.
And that brings us to the end of another thrilling episode on the Notes to My Legal Self AI Insights. We had a fantastic time exploring the fascinating intersection of law and AI with you. But hold on tight, because the adventure doesn't stop here. Stay connected with us on social media to continue the conversation, share your thoughts, and be part of our incredible community of legal enthusiasts. Together, we can inspire, learn, and make a real impact on the world of law and AI. If you enjoyed today's episode, we encourage you to share it with your friends, colleagues, and anyone else who could benefit from the exciting insights we discussed. Let's spread the knowledge and enthusiasm far and wide.